Hello.
Yes, ma'am, you can start.
Okay. Now, today we are going to study one case study, that is the Lobang case, which is asked in the question paper of 2005 in paper 2 of patent agent examination. So, so the case is there. Due to malnutrition, lot of people in Lobang, at least developing, it is a least developing country, are suffering from tuberculosis. Okay, then Lobang has no manufacturing capacity for the manufacturing of simtadine, a pharmaceutical compound, which is very effective and cheap for the treatment of tuberculosis. However, it authorizes by notification, that is Cipla Limited in India, to manufacture and export the said pharmaceutical compound to Lobang. Cipla Limited informs that the pharmaceutical compound is patent protected in India by LISA USA, and therefore unable to manufacture and export due to fear of possible infringement. So this is the case. In that, we need to advise the client, that is advise your client, Cipla Limited, about various relevant provisions available under the Patent Act 1970 as amended in order to enable the said company to manufacture and export the said product to Lobang without any infringement. So this is the case, and we have to reply to the client or advise to the client for non-infringement. Okay. So how he can export that product to the Lobang without the infringement? So we have to give the advice related to this one. So this case is nothing but related to compulsory licensing. So how we can make the advice to the client? Can anyone told me what are the different provisions we have to use here? Hello.
Yes, we can hear you. You are audible.
So there are only how many students are there? Only 2 students. Hello.
Yes, we asked student to like join, like they are joining.
Okay.
Let's you can you can continue the session. They will join, then they will see.
Okay. Yeah. So in this case, how we can suggest to the client? So this is nothing but the case of health crisis. And when the health crisis is there, then we are using the provisions of compulsory licensing. So it is the health crisis in least developed country, that is Lobang. So we have to give the provisions related to compulsory licensing under Indian Patents Act 1970. So in that, we have to use the section 84. So what it says, at any time after the expiration of the 3 years from the date of the grant of a patent, any person interested may make an application. Hello. So under section 84, what it says, at any time after the expiration of 3 years from the date of a grant of a patent, any person interested may make an application to the controller for the grant of compulsory license on patent on any of the following grounds. So there are 3 grounds. That is that the reasonable requirement of a public with respect to the patented invention have not been satisfied. Okay. Second one is that the patented invention is not available to the public at a reasonably affordable price. And third one is that the patented invention is not worked in the territory of India. So as per section 84, any person who is interested or already the holder of the license under the patent can make a request to the controller for grant of compulsory license on expiry of the 3 years when the above conditions are fulfilled. So another provisions are also there. However, compulsory license may also be granted when under section 92 capital A, 92 capital A and 92 in that subclause 1. So 92 capital A says for export under exceptional circumstances. So this is the case of export because what they are asking, they want to export the product to Lobang, okay, without any infringement. So in this case, we have to use this section 92 capital A for export and under exceptional circumstances. Second one is the section 92A in case of national emergency, extreme urgency or public non-commercial use by notification of the central government. So this is not used here. And section 92 capital A1 to a country which has insufficient or non-manufacturing powers in the pharmaceutical sector to address the public health. So in between these three provisions, more specifically, we have to use the section 92A subclause 1. That is for the related to public health or to address the public health and the country in which the manufacturing capacity for the pharmaceutical sector is not sufficient, then we have to use this provision. So in our question, what is the main cause? There is the malnutrition and in very big amount, that is large scale malnutrition is there in Lobang. And this is the least developed developing country.
Is developing country.
Yeah, yes. And it is suffering from the TB. So health crisis is also there.
Yeah.
Okay. Then we have to advise on the basis of this the case of a least developed country, that is the Lobang, and we have to cure the health crisis here. So which provisions generally we are using here? So under section 84, we know that there are the three criterias. That is the ground we can ask for the compulsory license. And after that, in under section 92A, there is in 92A, first one is for export under exceptional circumstances. In that, when we study the clause 1, it is more specifically considering the or addressing the public health. Okay, so we have to use 92 capital A subclause 1 here.
Yes.
To address this problem. So how we will write down? Let's see in the next one, next slide, that is global perspective on compulsory license. What it is saying, this phenomenon of compulsory licensing is a hugely debated issue. Many developing countries are giving importance to the compulsory licensing because of the unavailability and unaffordability of the medicines. And they are continuously granting more and more compulsory licenses. The developed countries of Europe, USA are opposing this view as it would make innovation difficult for the pharmaceutical companies. Okay, so if the compulsory licensing is given by means of any, it is directly granting, then there is the objection related to that because R&D, it required a huge amount, and it will comes after the after it is based on the primary patents actually. So to avoid the evergreening, this clause is inserted. In the case of global perspective, what it says related to compulsory licensing is it directly.
But for compulsory licensing also, ma'am, they will not be paid any royalty. Hello.
Yes. No.
So So my question was like, during compulsory licensing, would they be paid any royalty by, like, if you even assume that today India does not have any invention on COVID medicine. So if we have to get a compulsory license from some other pharmaceutical company of UK or Europe, okay, so we will be paying certain. So the government of India will be paying certain loyalty to get that, and then hand it over to the respective pharmaceutical company who can manufacture here in India. Or
Yes.
even if we don't have any manufacturing facility, if we are direct, we cannot directly import the medicine, right? So for even for importing medicine, we need to pay certain royalty. Yeah,
Yes.
we understand that there may be some tax exemption or that can be done because it's a pandemic, but still the companies will be in the profit only.
Company is in the profit, but the profit is very minimal. Na? The royalty amount is very less as compared to if they are directly selling the patented invention or the drugs with the very high cost. Then as compared to that, the royalty is very minimum. It is only 2 to 3%. If they are getting the profit of 100%, then when we compare with the royalty, then it is very less.
Okay.
And that's why they are developing countries are opposing. Okay, so in this case, how we can draft the answer for this one? So in this case, Cipla Limited can grant compulsory license under Section 92, capital A, subclause 1, and manufacture the drug for TB and export it to Lobang to address the public health. So in this way, we have to write down when the question is asked in any paper too, then we have to write down all these provisions, that is the under which circumstances we will apply for compulsory licensing, and what are the another provisions which are related to the grant of compulsory licensing and which is related to address the public health and to export that component. Okay, so and we have to write down the global perspective related to it also. So it also holds some marks, and after that you have to conclude that that by writing that the grant of compulsory license under Section 92 capital A subclause 1, we can that is Cipla Limited can grant the compulsory license and manufacture the drug for TB and export it to Lobang to address the public health. So this is the one case. Okay. So if you
Here
want,
the Cipla cannot grant, right? The controller has to grant it, right? Then your answer says Cipla can grant the license. So do we have to write in that way, or
in this case,
the controller can ask the
yes.
Cipla to?
Yeah. Good
Yeah, so,
observation. Yes.
yeah. So that's where I thought like the controller may request the or the controller may order.
Yeah, yes. So once again, you have to read this and understood this one, because this question is very essential, and in this type of questions may ask in the paper too.
So do you want me to read it?
Yes.
Yeah. Due to malnutrition, lots of people in Lobong, the least developing country, are suffering from TB. Lobong has no manufacturing capacity for the manufacturing of simtadine, a pharmaceutical compound very effective and cheap for the treatment of tuberculosis. However, it authorizes by notification Cipla Limited in India to manufacture and export this said pharmaceutical compound to Lobong. MS Cipla Limited informs that the pharmaceutical compound is patent protected in India by LISA Inc. USA, and therefore unable to manufacture and export due to fear of possible infringement. Advise your client, Mr. Cipla Limited, about various relevant provisions available under the Patents Act 1970 as amended in order to enable the said company to manufacture and export the said product to Lobong without any infringement. It is a bit tricky.
So,
This
is
one, I
in
guess.
this question, have you studied infringement related analysis?
The parent company is Liza Inc. USA, right?
Mm-hmm.
Even Cipla does not owns the invention, I guess. Pharmaceutical compound very effective and
Yes.
cheap for treatment. However, it authorizes by
So
notification.
patent is protected in India by Lisa USA. Okay.
Huh. So Lisa has already given a compulsory license, or at least they have hired Cipla for manufacturing that product in India. But Lisa owns the patent, right?
Yes, yes. In India, Lisa USA owns the patent.
Owns the patent. Yeah.
Yes.
So then the controller may either request, even if we just conforms to Cipla, it should not work, right? They should ideally write an email to Lisa Inc., right?
Okay.
Because Lisa Inc. owns the patent, right? So if a point of contact from Cipla is been identified, and if we write an simple email to them, then that also will not work, right? And there will, I don't think so there will be any Cipla mentioned in the patent anyway, if Lisa owns the patent.
No, Cipla wants that patent, na? So Cipla want to manufacturing and export that pharmaceutical component to Lobang.
Lobang, okay.
Yes,
Okay.
yes. So Cipla want compulsory license. So he will fill the form, then form for applying for the CL, compulsory licensing, to the controller, right? And the controller asked to the Lisa USA.
And also, so in the fourth line of the
yes.
it is mentioned that, however, it authorizes by notification Cipla Limited in India to manufacture, because the Cipla is having authorization to manufacture and export the said pharmaceutical compound to Lobang. So Cipla wants that patent rights to come manufacturing it and export it.
Or it authorizes by notification, that is Cipla India in India, to manufacture and export the said
that's what I was coming from. Lisa, first they initially got the patent, but they are not the true manufacturers. They were earlier manufacturing they have earlier authorized Cipla to manufacture the drug and export it to US or supply it in India, but they cannot supply to any other country. That might be the case.
If any patent is granted in USA, okay, so is it having a matlab, it is a 2005 question paper, na, right? So
notification in India to manufacture and export the said pharmaceutical.
So they are asking, that is he can manufacture and export without any possible infringement, fear of any possible infringement. So have you already studied the infringement related provisions, na? So can we apply any provision here?
Ma'am, I think here some confusion is, the question leads some confusion. I think we need some more information about this, whether which company having the patent, because here the fifth or sixth line informed that Cipla informs that pharmaceutical compound is patented, protected in India by Lisa USA, and therefore unable to manufacture and export due to fear of possibility, and advise the claim Mr. Cipla for the various. And Cipla does not having any patent in India about this pharmaceutical medicine to cure the TB.
Okay.
No, I am asking.
Is Cipla having मतलब ऐसा भी हो सकता है ना? In this case, that is, you are saying that the patent is holded by Lisa USA, right?
So Lisa having the patent rights in India.
It is protected under USA only.
Ma'am, let's make it simple.
Hmm.
लीजा के पास पेटेंट है, ओके,
Yeah.
एंड सिप्ला के पास लोबांग का गवर्नमेंट आया या इंडिया का गवर्नमेंट गया, that we don't know. Or else Cipla might have received response to get this drug manufactured and supplied to Lobang. Okay. Now Cipla has to apply for the compulsory license. Then only controller will say, or Lobang government approaches the Indian government and then it goes to controller, and controller mandatorily looks for that particular thing. So without any compulsory license application, controller may not deal with any certain things, right?
Yeah. Yes.
Okay. So in that case, Cipla does not own any authorization till date. But since Lobang government asked Cipla to manufacture this thing, then they when they have cross-checked, they identified that Lisa owns a patent, and that's where they approached the controller to provide a compulsory license, because it's an mandatory requirement to manufacture and export this drug to Lobang because of the pandemic situation in Lobang. Okay. And then the controller can give the license to Cipla from Lisa, because it is the patent is applied in India, and as per the Indian Patent Act under section 92 1A, sorry, 92A1, 92A subsection 1, the controller can grant a compulsory license to Cipla because the pandemic situation which is arised in Lobang, and the Lobang does not have any manufacturing facility of pharmaceutical drug Sebatin in their country, right? So if you write in that way, will it be suffice?
Yes, it is. But you have to give first the provisions under which we can ask for the compulsory license. Then after we have to write down that.
So we need to write what is the form required, and under which section they can apply for that form. Those are the things we need to.
Yes. Also forms you can write down.
Yeah. Okay.
Okay. Yes.
Yeah.
And sections you have to write down. And you have to give the global perspective related to CL also. What is the global perspective? After that, you have to conclude in this way.
Okay.
That is the answer.
Okay.
So, do you have any other case related to compulsory license in paper 2?
No, not really, ma'am. Like I at least I didn't went through. So.
Okay. So, compulsory licensing chapter is over here actually, because I have covered all the sections, but we have to read all the provisions. 1 minute. So, I will open that document.
But I guess most of the times the pharmaceutical companies will only face this issue, right?
Yes.
Because normally we don't see pandemic situations. The other domains may cater the pandemic situation.
So when we study the infringement related suits concerning infringement of patent, so can we add any infringement related provision in this case study? Hello?
Hello, sorry, ma'am, I was speaking on mute.
Ha,
So there is no
so-
such infringement happened here, right? So
Mhm.
why do we have to mention the infringement clause here?
Right. So we have to only here need to add
Yeah. So
yes provisions related to compulsory licensing.
compulsory license. Yeah, I have one more doubt. So now, if assume if CIPLA is applying for compulsory license, means they will apply it with Form 17, right? And what will be the fee structure? So they ideally have to apply it because they didn't manufacture it till date. Okay. What is the fee they need to pay? Whether it will be just give me 1 second. I was looking at this. Yeah. So whether it will be 12,000 or whether it will be 2,400.
12,000 is given to matlab in which schedule it is given?
12,000 is given to others alone or with natural person or startups or small entity.
No, it is not a small entity, no.
No, it is coming under others and others.
There are how many sections are there?
I have only 2 sections for
Two
e-filing.
sections. Okay, so second section, second column, what they given?
Yeah, second column is what they have provided this much. Just give me 1 second. I lost. Yeah, 12,000. Second column.
So 12,000 and it is for who is applying?
CIPLA.
No, CIPLA is applying, but who is CIPLA?
CIPLA is an organization, right?
Yes. So it is a big organization, na? So
Yeah, it's a bigger. No, that is where my point comes. Like CIPLA as a company is a big organization, but they didn't manufacture this particular drug till date. And they also want to manufacture only because they to address the pandemic situation.
Yes.
So they are gaining out of it.
This fees is for it is related to the filling of the form. So you cannot fill this form until and unless you have to pay that fees.
Okay, so now after filling this form, does CIPLA will be in profit or the Lisa will be in profit?
No. As a CIPLA want the compulsory licensing to make that to solve that problem related to lobang, right? So CIPLA he himself want na. So the organization wants to manufacture that drug and export that drug.
Okay.
So it is they have something behind that one, na? So they want to address that problem. That's why they want to manufacture.
Okay, so think hypothetical.
Something like CSR or there are other provisions. Yeah.
ठीक है, एक hypothetical situation लेते हैं. Does Lisa also get a chance to deny?
Yeah, Lisa has to get has the chance to deny, but it is not possible because the whole authority, the main authority here is that controller, no?
हाँ, तो Lisa can say that why CIPLA? I can only manufacture and deliver it to Lebong, right? Lebong or what?
If Lisa want to do that, then it is very good. If he can do that, then why CIPLA is then offering?
Approaching.
Yes.
Okay.
Yeah. So working of patents, compulsory licenses, and revocation. So in the first one, that is definition for patented articles and patentee is given. So patented article includes any article made by a patented process. Okay. And patentee includes an exclusive licensee. As we already know that, but the definitions are given in 82. So these definitions can also be asked. Okay.
Yeah, they come under
It is
section 2, right?
article and patentee. Yes. So these definitions can also be asked. For 1 or 2 marks, it can be asked. 83 general principles applicable to working of patented inventions, as we already studied that. Without prejudice to another provisions contained in this act, in exercising the powers conferred by this chapter, regard shall be had to the following general considerations, namely, the patents are granted to encourage inventions and to secure that the inventions are worked in India on commercial scale and to the fullest extent that is reasonably practicable without undue delay. That they are not granting merely to enable patentees to enjoy a monopoly for the importation of the patented article. That the protection and enforcement of patent rights contribute to the portion of technological innovation and to the transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge and in the manner conducive to social or economic welfare and to balance of rights and obligations. So when we can say that patented invention is working very in India, then these are the A, B, C, D, E, F, and G. Okay. So if it covers all these clauses, then we can say that it is working in India. So in that one clause is there, that is the C, that the protection and enforcement of patent rights contribute to the promotion of technological innovation and to the transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge and in the manner conducive to social or economic welfare and to a balance of rights and obligations. Next one, that the patents granted do not impede protection of public health and nutrition and should act as an instrument to promote public interest, especially in sector of vital importance of socio-economic and technological development of India. Next one, that the patent granted do not in any prohibit central government in taking measures to protect public health. That the patent right is not absurd by the patentee. Okay. Not absurd by patentee. Okay. Or a person deriving title or interest on patent from the patentee, and the patentee or a person deriving title or interest on patent from patentees does not restore to practices which reasonably restrain trade or adversely affect the international transfer of technology, etc. And next one, and the patents are granted to make the benefit of the patented inventions available at reasonably affordable prices to the public. Okay, tell me on section 83, which type of question can be asked? In paper 2, if any question is asked related to section 83, then which type of question it may be asked?
What if we don't we don't manufacture a product out of a patent? These are then we need to mention all the reasons, right?
Okay. So here in section 83 clause A, the commercial scale and to the fullest extent, that in the reasonable practice without undue delay. So what is the meaning of this undue delay means?
Undue delay is the period that is given after the grant. That there is a 3 years period for revocation, right? If you don't come up with a product against your patent that you have obtained, and within 3 years of time, anyone can apply for revocation of your patent because the patent is not commercialized.
Okay.
Because in
So-
India, we also have the revocation rule, right? That if a person is applying for a patent, then he also need to commercialize that as a product for public use.
Yes, yes, yes. So, but you know that, na, if there are 100 patents are granted, suppose, then there are only a few patents, they can be good enough to become commercialized and transfer that technology to for the licensing. So,
But still, if they don't come up with any product on any particular patent, the person interested will still have the chance to revoke that.
okay.
But to do that, he needs to come up with a product.
Yes, yes, yes.
Only if I only revoke it and I sit idle, then that should also not work.
Okay.
Consider a case like a person A has got a patent and person B is a person interested. Okay. And he goes and applies for revocation of person A's patent. Okay. Then he has to prove that he can come up with a product in future, right?
Yes, yes, yes. So he already have something which is
Which is in line.
a-
That is why we are calling him person interested. Otherwise, he will also be a normal person. And normal person cannot be cannot apply for revocation.
Okay, okay, okay. So this first one. Second, that is 83 clause B, that they are not granted merely to enable patentees to enjoy a monopoly for the importation of the patented article. So what do you understand by monopoly for the importation of patented article? Is this related to infringement or not? This clause 83B. Have you studied the infringement related to related provisions?
No, ma'am, not yet.
Not yet. Okay, okay. So the monopoly for the importation of patented article. Okay. So what it means now, when you grant a patent, then all the rights are going towards that patentee, right? That applicant. Okay. So he is the only person who can manufacture that product and sell that product in the market. So he is having the monopoly on that technology. When we can say that importation of a patented article, then this section is related to the infringement. Okay, suppose any person, if suppose person A granted a patent related to XYZ technology in India. Okay, so he will take that monopoly within the boundaries of India. So if another person who is having the similar patent, similar type of patent, and he want to export the same product into the India, is it possible? Hello.
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 Yeah,
So I
sorry,
am
ma'am. You were asking something?
yes, I am asking about the importation of patented article. So what do you understand by this, by the meaning of importation of patented article?
So if a person holds a patent in India already, he cannot
Mhm.
import a similar patent from others. Is it like that to enjoy the monopoly?
No, it is not like that. When you study the infringement related provisions, then you can understand this one. Okay. Let's see the next one. I will give you one example related to this one in the next lecture. Okay, let's see the third one, that is 83 subclause C, that the protection and enforcement of a patent rights contribute to the promotion of technological innovation and to the transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge and in the manner conducive to social and economic welfare and to a balance of rights and obligations. So promotion of technological innovation. It will comes under the non-commercial use. Okay, to the transfer and dissemination of technology, to the mutual advantage of producers. So mutual advantage of producers, it is dealing with the cross licensing of that technology and users of technological knowledge and in a manner conducive to social and economical welfare. Okay, so if suppose that knowledge is in economical or social welfare and to a balance of rights and obligations. So you can use this one in the present case of a COVID vaccine. So how you can interpret this section related to COVID case? So how that vaccine is developed? Have you know that how the vaccine is developed? Hello. Hello.
Hello, ma'am.
Yes.
Ma'am, are you asking some question?
Yes, I am asking some question. So
What?
have you able to get my screen? That is section 83, general principle applicable to working of patented inventions.
Yes. Yes, we are
Okay.
getting.
That clause C is there, that the protection and enforcement of patent rights contribute to the promotion of technological innovation and to transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge and in the manner conducive to social and economic welfare and to a balance of rights and obligations. So I am asking that is this clause is relevant to present case of COVID vaccine or not? Have you have any prior knowledge related to how the vaccine is formed, how it is manufactured, and if any question is asked relevant to that, then can we apply this section 83 clause C in that?
Ma'am, this conducive means what?
Technology and in a manner conducive to social and economical welfare. Matlab we have to apply that for the social and economical welfare.
Yeah, it seems that it is applied in this pandemic COVID-19 situation.
Yes. And
I
how
think it
how
must.
the technological innovation is happened? How the vaccine is prepared?
It is prepared in R&D center. Later on, because if we are talking about the COVID vaccine by the Serum Institute, so it is discovered by the Serum vaccine in their R&D center, and then afterwards the compulsory licensing is given to government.
But as we know that the vaccine is prepared at various laboratories, and it depends upon the genetic data of that specific territory. Suppose the vaccine is formed at China, or in Russia, or in India, or in US, then they have firstly prepared that coding, and after that they are manufacturing that vaccine. So that the sequence listing or the DNA sequencing is also did na. So how the promotion of technological innovation is happened in that case? I am asking that question.
But Serum is making this vaccine by the RNA technology.
Okay.
And the serum, the way of invention is different if we are comparing with the Pfizer and Russian Putin vaccine.
Okay.
So this is the way, means our technology is totally different. And this is the main reason that the European countries, they denied to accept the serum vaccine, Covaxin.
Okay.
Because our vaccine is RNA theme related.
Okay.
As I know.
Okay. No, it is prepared for a specific territory. So the genes for the Chinese people, they are different, and in Indian people, it is different. So as we know that, have you heard about the CRISPR technology? CRISPR?
No, ma'am.
Okay. So CRISPR-Cas9, the Cas9 is a protein which is discovered, and by means of a CRISPR, we can edit any type of DNA, and we can change the DNA, or we can, if there are some type of genetic disorder, so we can replace that genetic disorder by using CRISPR-Cas9.
Okay.
So the whole thing related to technological innovations, generally what happens now when there is any pandemic situation is there. So we have to use all the resources in the world, and by using all these resources or all the technologies, we have to innovate the new thing, and after that we can apply that for the social or economic welfare.
Okay.
So this type of case might be asked in the paper too. Okay.
Yeah.
So in the
This situation related.
So you have to study that how the vaccines are developed, and why they are developing the different types of vaccines for different territory, and the CRISPR technology also you have to read, and the proteins related to it, that is Cas9, or there are another proteins also. Okay, so maybe this type of case study maybe they may be asked. Also, the case study related to genetically modified babies.
Okay.
Okay, it can also be asked in paper too.
Okay, ma'am.
So next one, that the patents granted do not impede protection of public health and nutrition. So as we saw that case of Loven, that is it is related to health and nutrition, right? The patents granted do not impede protections of public health and nutrition, and should act as instrument to promote public interest, especially in sector of vital importance of socio-economic and technological development of India. Next one, that the patents granted do not in any way prohibit central government in taking measures to protect public health. So if in any way they are prohibiting the central government,
ma'am, this section 83F, I unable to understand.
Okay, in F, that the patent right is not abused by the patentee or person deriving title or interest on patent from the patentee, and the patentee or a person deriving title or interest on patent from the patentee does not resort to practices which unreasonably restrain trade or adversely affect the international transfer of technology. Okay, so as we have the another type of trade related aspects of intellectual property rights. Okay, so if any person or a patentee or the person related to that patent, which is the patent, if the patent rights are not abused by that person. Okay, and the cases are which are the cases? The practices which unreasonably restrain trade or adversely affect the international transfer of technology. So in this case, we can say, 1 minute, I will show you that, as you know about World Trade Organization.
Yes, ma'am, WTO.
So what it is doing exactly? What is the purpose of WTO formation?
I heard, ma'am, but deeply I have not studied yet.
So WTO is a World Trade Organization, is the only global international organization dealing with the rules of trade between nations. Okay, so
Okay.
the trade between nations also happens, as we know that. So before WTO, there is a GATT, GA. General Agreement on Tariffs and Trade.
Okay, GATE.
GATT, GATT, GATT.
Okay.
So General Agreement on Tariffs and Trades.
TRIPS also comes under WTO.
Yes. TRIPS is a trade-related aspects of intellectual property rights. And
Yeah, that I know. I'm asking, like, TRIPS is also formed by WTO, or is it some?
Yes, it is formed by WTO.
Yeah.
It is under WTO. The agreement is formed under WTO.
Yes. Yeah.
And it is a comprehensive multilateral agreement on intellectual property. So it is not a bilateral. Bilateral is happened between two countries, but it is multilateral means there is so many countries, 167. There are so many countries under that convention. So also Paris Convention is there. The similar way the TRIPS is there.
Yes.
And WTO is the main organization under which all these happen. So the practices where the restraint of trade will happen, or if the adverse effect on the international transfer of technology is happened, then in that case we can list this section, that is section 83F. What it says, the general principle applicable to working of patented invention. If the unreasonable restraint of trade or adverse effect on international transfer of technology happen, then we can say that it is not working properly, that patented invention is not working properly. And the last one is that patents are granted to make the benefit of patented invention available at reasonably affordable price to public. So yes, as we know that any patent granted and a patentee have the right to get benefited by that patent, but the patent is also available at reasonably affordable prices to the public. Okay, so then and then only we can say that it is working. Otherwise, if patentee is benefited by that patent, but the affordability is not there, then it will going for CL then, because it is not, we can consider it is not worked in the territory of India. So these are the some provisions, that is general principles which are related to the applicability of patented inventions in India. As we already studied section 84, and after that 85.
Revocation of patents.
Yeah, this is the one I was talking about.
That is revocation of patents by the controller for non-working. So what it says, where in respect of a patent, a compulsory license has been granted, the central government or any person interested may, after the expiration of 2 years from the date of order granting the first compulsory license, apply to the controller for an order revoking the patent on the grounds that the patented invention has not been worked in territory of India. Okay, so there are the provisions given in 83. So in that, we can say, on that basis, we can say that it is not work in the territory of India, and on that provision, on that basis, the controller can revoke the patent. Or that the reasonable requirement of public with respect to the patented invention has not been satisfied, or that the patented invention is not available to the public at reasonably affordable price. So it is also listed in 83 now. Next one, every application under subsection 1 shall contain such particulars as may be prescribed, the fact upon which the application is based, and in the case of an application other than by the central government, shall also set out the nature of the applicant's interest. So this is also important, that is the nature of applicant interest. We already studied this one, right? The nature of applicant's interest. The controller, if satisfied that the reasonable requirement of public with respect to the patented invention have not been satisfied, or that the patented invention has not been worked in territory of India, or that the patented invention is not available to the public at a reasonably affordable price, may make an order revoking the patent. Every application under subsection 1 shall ordinarily by decided within 1 year of its being presented to the controller. Okay. So the time limit is also given here. So the revocation, if it is happened, then it will happen within the 12 months time. In the previous lecture, have we studied this power of controller to adjourn the application for compulsory licenses? 85 and 80, 84 and 85.
No, I think no.
Not, no? Okay. So the power of controller to adjourn the application for compulsory licenses in certain cases, in that clause 1 saying where an application under section 84 or section 85, as the case may be, is made on the grounds that the patented invention has not been worked in territory of India, or on the grounds mentioned in the clause D of subsection 7 of section 84, So tell me that section subsection 7D, what it is saying.
D says if the patented invention is not being worked in the territory of India on a commercial scale to an adequate extent or is not being so worked to the fullest extent that is reasonably practicable.
Okay. Okay. So
What is the meaning of this? How we will interpret them?
okay, section 84, right?
Yeah.
In that 7 and 4, no?
70.
If the patented invention is not being worked in territory of India on the commercial scale, on an adequate extent, or is not being so worked to the fullest extent that is reasonably practicable. Okay.
It means?
So commercial scale, it will denote that mass production should be there. Okay, and we have that ability to supply for each and matlab there is according to the population and according to the requirement of the people we are able to supply that product. On that basis we are able to manufacture that product and supply to the fullest extent at affordable prices. Then we can say that it is worked in the territory of India. And that practice is called as a reasonable practice. Okay.
Okay.
Hello.
Yes, ma'am.
So where an application under section 84 or section 85. Okay. So section 84 says what it says, section 84.
Yes, section 84 for the compulsory licensing.
Please read the title only, section 84.
84 compulsory licensing.
And section 85.
Revocation of patents by controller.
Okay. So when the application are under compulsory licensing and revocation, as the case may be, is made on the grounds that the patented invention has not been worked in the territory of India or on the grounds mentioned in the clause D of section 84, and the controller is satisfied that the time which has elapsed since the sealing of a patent has for any reason been insufficient to enable the invention to be worked on a commercial scale to an adequate extent or to enable the invention to be so worked to the fullest extent that is reasonably practicable, he may, by order, adjourn the further hearing of the application for such period not extending 12 months in the aggregate, as appears to him to be sufficient for the invention to be so worked. Okay. Provided that in any case where the patentee establishes that the reason why a patented invention could not be worked as aforesaid before the date of application was due to any state or central act or any rule or regulation made thereunder or any order of the government imposed otherwise than by way of a condition for the working of invention in territory of India or for the disposal of a patented article or of the article made by the process or by the use of a patented plant, machinery or apparatus then the period of adjournment order under this subsection shall be revoked from the date on which the period during which the working of invention was prevented by such act, rule, or regulation or order of government as computed from the date of the application expires. So this provision, if suppose we will take the case of plastic ban, okay.
Okay.
So how we can use this one, that is power of controller to adjourn the application for compulsory license, subclause 1. Just for example, we are taking the case of plastic ban. So working of invention was prevented by such act, rule, or regulation or order of a government as computed from the date of the application expires. So can we use this provision there? Can we have any relation?
Ma'am, we can say that the use of plastic bag was banned by the government. So because of that reason, the patentee was not able to manufacture it.
Okay.
And if somebody applies for the compulsory license, the patentee can present his case in the way that I was not able to work to the fullest extent because there were order from the government.
Okay. No, he is already working to the fullest extent, na. But if there is any act or a rule or a regulation which gives the ban on that product, that is what is that? The process or by the use of patented plant machinery apparatus period. Government imposed otherwise than by any way of a condition for working of an invention in a territory of India or for the disposal of patented articles or of the articles made by the process or by the use of a patented plant, machinery or apparatus. The period of adjournment ordered under this subsection shall be reckoned from the, that is reckoned means we have to calculate that date from that period, that is from 0 to reckoned from the date on which the period during which the working of an invention was prevented by such act. Okay, so अगर प्लास्टिक बैन हुआ है आज से, सपोज द डेट इज फ्रॉम 20 Feb 2022. Okay, so how we can calculate that date or that period? So it will be reckoned from that date, that is the order is if order is given on this date, that is 20 Feb 2022, then from that date on which the period during which the working of patented invention was prevented by such act, rule, or obligation. It means from 20 Feb we have to prevent the working of that invention. So the manufacturing is also stopped from the same date. And it is computed from that date of the application. Okay. So what is the, there is a difference between the application date or the reckoning date of that to stop the production? Is these two things are different, or is the both things are same? Because any type of question can be asked on this one, that date. Okay, so this is very important. Please read once, that is provided that in any case. So you have to read once again. That is section 86. 86. That is power of controller to adjourn the application for compulsory licenses, etc. in certain cases.
Section 1, an application under the section 84 or section 85 as the case may be is made on grounds that the patented invention has not been worked in territory of India or on the ground mentioned in clause D of subsection 7 of the section 84, and the controller is satisfied that the time which has lapsed since the sealing of the patent has for any reason been insufficient to enable the invention to be worked on commercial scale to an adequate extent, or to enable the invention to be so worked to the fullest extent that is reasonable practicable. He may, by order, adjourn the further hearing of the application for such period not exceeding 12 months in the aggregate, as appears to them to be sufficient for the invention to be so worked, provided that in any case where the patentee establishes that the reason why the patented invention could not be worked as aforesaid before the date of the application was due to any state or central act or any rule or regulation made thereunder or any order of the government imposed otherwise than by way of the condition for the working of the invention in the territory of India, or for the disposal of the patented article, or for the article made by the process or by the use of patented art, machinery, or apparatus, then the period of adjournment order under this subsection shall be reckoned from the date on which the period during which the working of the invention was prevented by such act, rules or regulations or order of government as computed from the date of application expires.
Okay, so the period of adjournment order, it is calculated from the period during which the working of patented invention was prevented by such act or rule or regulation.
Right.
Yes, yes. Okay.
12 months.
Yeah, yes, 12 months. And it is the aggregate, 12 months in the aggregate as appears to him.
Okay.
Yeah. Next one, that is 86 clause 2. No adjournment under subsection 1 shall be ordered unless the controller is satisfied that the patentee has taken time, promptitude, adequate or reasonable steps to start the working of an invention in the territory of India on commercial scale and to an adequate extent.
It means what, ma'am?
No adjournment. Adjournment is also the order, okay? One type of order given by that government or controller, okay? No adjournment under subsection 1 shall be ordered unless the controller is satisfied that the patentee has taken with promptitude adequate or reasonable steps to start the working of invention in territory of India. If the controller is satisfied that that patentee is having that sufficient adequate capital, or he is able to take that reasonable step to start the working of to do the manufacturing of that patent in the territory of India and to give the patent at affordable price and sell the patent at affordable prices, and he can do the mass production, okay, then that type of adjournment is not given.
Promptitude adequate means what, ma'am?
Promptitude adequate means quickly he can have that adequate capital. Matlab, he is having that type of investors, and also he is able to take that reasonable steps. It means he is having the total knowledge related to that development of that drug or the technology or the patented article. And he can directly commercialize it on the mass scale, on the mass scale. Okay. Then this type of adjournment is not given. That type of order is not given, which is given in subsection 1. Okay, we have already read that. It is not given under these circumstances because the patent is able to do or commercialize that one on the fullest extent. So that type of order is not given in this case. They are saying that. Okay, procedure for dealing with application under section 84 and 85. Yes. So when the controller is satisfied upon consideration of an application under section 84 or section 85, that a prima facie case has been made out for the making of an order, he shall direct the applicant to serve copies of application upon the patentee and any other person appearing from the register to be registered in a patent in respect of which the application is made, and shall publish the application in official journal. The patentee or any other person desiring to oppose the application may, within such time as may be prescribed, or within such further time as the controller may, on application made under made either before or after the expiration of the prescribed time, allow give to the controller notice of opposition. So have you studied the opposition provisions related to opposition?
No idea, ma'am.
Mm.
Some of the classes I missed due to some reason.
Okay. Any other person there?
Saloni, whether we have covered the opposition or not?
Yes, post-grant opposition we have covered.
Okay. So it is also post grant because it is after the grant of the patent. So CL comes after the grant of patent only.
Yes, ma'am.
So in the post grant opposition, have you studied any term related to section 84 or 85?
Ma'am, you please cover it. I missed.
Okay. The patentee or other person desiring to oppose. Okay, suppose when the opposition comes, can you explain why opposition comes?
Ma'am,
Opposition can
notice
happen
of
in 2
opposition
ways.
can be given only after within 1 year of the grant of patent.
Okay, No, I'm asking that why the opposition is come. Post grant opposition, why it is coming? What is the reason behind the opposition?
It may be the several reasons.
If the person interested identifies that someone has infringed his idea or his prior application, then he may go for an opposition.
Okay. Suppose one patentee granted a patent related to suppose one instrument which is used in the kitchen. Okay. And there is another person who is already manufacturing that product, the similar kind of product.
Yes.
And he is having a large amount of client base. Okay. So and he is also having the patent related to that that type of product. Okay.
Yes.
So yes. So if that person knowing that there is another type of that is a device which is relevant to my device, which is related and similar to my technology. Okay. So he can oppose if he is having the priority, then he can give that opposition notice.
Yes.
For the infringement. In that case, the infringement is happening, no? Right?
So infringement will be decided by the controller, but he has a right to oppose.
No, infringement is not decided by a controller. It is after that one. But if suppose that that patentee is doing the freedom to operate search, Okay. Suppose a patentee haven't did the FTO before launching the product into the market, and that product is infringing some another person's rights, patent rights.
Yes.
That another person can oppose, that is give the notice of the opposition to the controller on the basis of that infringement. Yeah. So the patentee or any other person desiring to oppose, because he is losing some type of he is having some interest, and also the revenue, he's facing some challenges related to that is obviously if there are 2 or 3 similar type of patented articles are in the market, then it is directly affect the profit. So due to that, he will give the notice to the for the opposition. Okay. So desiring to oppose the application may within such time as may be prescribed, or within such further time as the controller may on application made either before or after the expiration of the prescribed time, allow or give to the controller notice of opposition. So what is that timing? That is prescribed timing by controller. After the grant of patent, within
1 year.
Within 1 year. So 12-month time is prescribed. Okay. So within 1 year he can do.
Yes.
Next one, any such notice of opposition shall contain a statement setting out the grounds on which the application is opposed. So here also the grounds is given in the similar case as in the case of CL, we will give the grounds. So when we are making the opposition, the grounds are also listed there.
Yes.
Next one, where any such notice of opposition is duly given, the controller shall notify the applicant and shall give to the applicant and the opponent an opportunity to be heard before deciding the case. So the opportunity is also given for that applicant to be heard.
Yes.
And controller
3 months of time.
3 months of time. Okay.
Yes.
So this is listed in that is a procedure for dealing with application under section 84 and 85. So how the procedure was there. Okay. Next one is section 88, that is powers of controller in granting compulsory licenses. Actually, we already studied this one, right? How the controller
opposition ka compulsory license may why they have made this sections under this one.
You are talking about section 87.
Yes. So from 84.
So
from 84, we are talking about the compulsory license, right?
Yes.
So 84 is more related to compulsory license. 85 is more related to the working of patent, right?
Yes.
So
but they are interrelated. That's why it is inserted, because we cannot separate each and everything, no? So.
Okay.
Next one, the powers of controller in granting compulsory licenses. In that subsection 1, where the controller is satisfied on an application made under section 84 that the manufacture, use or sale of a material not protected by the patent is prejudiced by a reason of condition imposed by the patentee upon the grant of licenses under the patent, or upon the purchase, hire or use of the patented article or process, he may, subject to the provisions of that section, or the grant of licenses under the patent to such customers of the applicant as he thinks fit, as well as to the applicant. So controller having the ability to order the grant of license under the patent to such customers. Okay, so that customer must have the ability to purchase, hire or use of the patented article or a process. Then controller having that power to grant the license under this provision. Second one, where an application under Section 84 is made by a person being the holder of a licensee under the patent, the controller may, if he makes an order of a grant of a license to the applicant, order the existing license to be cancelled, or may he, if he thinks fit, instead of making an order for a grant of a license to applicant, order the existing license to be amended. So license can be cancelled or amended under these provisions of Section 88, Clause 2. So why it is cancelled? If controller makes an order for a grant of license to the applicant, order the existing license to be cancelled, or may, if he thinks fit, instead of making an order for a grant of license to the applicant, order the existing license to be amended. So this is very important. So tell me what you understand by this. Why the license is amended?
When an application made by a person being the holder of the patent, the controller may, if he makes an order for the grant of license. So after certain time, the patentee will may again have the right to take the license back, right?
Yes.
So for that also he can apply. Yeah. See, if somebody have to take the same case, so after the tuberculosis have been cured to some extent, where it will not be called as pandemic anymore in that particular country, the LISA should have a right to take their patent rights back from Cipla, and
Yes.
can stop Cipla from making and selling the products.
Yes. So the person being the holder of a licensee. So here that what is the name? Liz USA, na? Under the patent, the may he makes an order for grant of licensee to the applicant. So he applied, he gives the license to Cipla. So order the existing license can be cancelled.
Can be cancelled, yes.
Or may, if he thinks fit, instead of making an order for a grant of a license to the applicant, order the existing license to be amended.
Yes.
If the license is amended, then
if the license is amended, that will be agreed by both the parties. Based on the both what agreement they will come up to, they may decide. The controller may decide whether to amend it or whether to cancel it on hold.
Yes. Where two or more
This goes on Form 19 with same fees, right?
Yes.
Yeah. Okay.
For the cancellation of compulsory license, which form we can use?
Form 19.
Form 21 you can check once. Form 21 for the cancelling of compulsory license. Is there any form related to that or not? You can check in the form.
Sorry. Yeah, Form 21. Sorry. Form 21 for termination of compulsory license, and then fees is 12,000.
Okay.
And this has to go under Section 94.
Section 94. Okay. Okay. So next one, that is Section 88(3), where two or more patents are held by the same patentee.
So this is for only termination. The one which you have said is for only amending, right? So will it be on the same form, or is it a different one?
Is there related to it is given under Section 88? You can check in Form 19 also.
In Form 20 there is Section 88(4).
88.
But 88 is only in one form. Yeah, that is on Form 20.
20. Okay. And 88.2 is given there in any
No.
form?
Not really.
For the amendment of existing license.
Amendment का ऐसा कुछ दिया नहीं है. Let me see the form.
Form 20 is used, I guess. For
Yes,
Okay,
88.4 and Rule 100 is what is been given.
Okay. Can you read the title of that form? Form 20.
application for revision of terms and conditions of license under
Yes.
section 88.4 and rule 100.
Rule 100,
Yes,
yeah.
yes. So this form is used, form 20 here.
Okay.
That is, you can amend that existing license there, no?
Yes, yeah.
Okay, let's see the next one, that is section 88.3. Where two or more patents are held by the same patentee and an applicant for where two or more patents are held by the same patentee and an applicant for a compulsory license establishes that the reasonable requirements of a public have not been satisfied with respect to some only of the said patents, then if the controller is satisfied that the applicant cannot efficiently or satisfactorily work the license granted to him under those patents without infringing the other patents held by the patentee, and if those patents involve important technical advancement of considerable economic significance in relation to other patents, he may, by order, direct the grant of license in respect of the other patents, also to enable the licensee to work the patent or patents in regards to which a license is granted under section 84. So in this case, what is happening? The patentee having the multiple patents. So there are two or more patents there. And if the controller is satisfied that the applicant, which is the applicant who is applied for compulsory licensing, cannot efficiently or satisfactorily work the license granted to him under those patents without infringing the other patents held by the patentee, and if those patents involve important technical advancement, matlab the patents who doesn't hold any CL compulsory licensing, but these patents are having holding some important technical advancement of considerable economic significance in relation to the other patents, then controller may by order direct the grant of license in respect of the other patents also, to enable the licensee to work the patent or patents in regard to which a license is granted under section 84. So as you will know that there are different types of patent of additions is there. So the basic patent, the parent patent is there, and other improvements are also added. And suppose can we have a patent number for patent of addition, the different patent number or the same patent number? Have you know about that? In case of patent of addition,
Ma'am, in patent of addition, the number is different, but the reference is to be added to the main patent.
okay. So bibliographic data is added or reference is given.
Yes, ma'am.
Okay. So if suppose there is a X patent, on the basis of X, Y, Z is there. Okay. And for the Z patent, the applicant is applied for compulsory licensing. and that applicant is not able to efficiently or satisfactorily work with that patent because he don't hold any knowledge related to X and Y, which is very important to execute the Z. Okay, so in this case, what will controller do? Controller can also grant the compulsory license related to the another patents, that is X and Y patent. So this clause is saying that thing. Okay.
Yes, ma'am.
Okay. So read once. That is 88.3.
Where two or more patents are held by the same patentee, and an applicant for a compulsory license establishes that the reasonable requirement of the public have not been satisfied with respect to some of the said patents, then if the controller is satisfied that the applicant cannot efficiently or satisfactorily work the license granted to him under those patents without infringing the other patents held by the patentee, and if those patents involve important technical advancement of considerable economic significance in relation to the other patents, he may, by order, direct the grant of license in respect of the other patents, also to enable the licensee to work the patent or patents in regard to which a license is granted under Section 84.
Okay. Okay. And which form we can use to apply for that compulsory license? Is the same form, or we can apply in the different form?
I think, ma'am, same form 17.
Same form, yes, form 70. Okay, next one, section 88, clause 4, where the terms and condition of a license have been settled by the controller, because terms and conditions are settled by controller only. The licensee may, at any time after he has worked the invention on the commercial scale for a period of not less than 12 months, make an application to the controller for the revision of the terms and condition on the grounds that the term and conditions settled have proved to be more onerous than originally expected, and that in consequences thereof, the licensee is unable to work the invention except at a loss, provided that no such application shall be entertained a second time. So why the revision of terms and condition can be granted? Why we need the revision of terms and condition, as the already it is decided by controller. So when the actual case is happening, when you actually doing all the processes and you are actually working on that patent on the commercial scale, so if the outputs are different, in that case, if we plot the terms and condition on the basis of probability, so this is the probable outcome of by these terms and condition, but after working on that patent on the commercial scale, we saw that the time required to do it on the commercial scale, it will and we have to also change the terms and condition on that basis the license is granted. Then in that case also we can amend that terms and conditions. Okay, so here what is given: where the terms and condition of a license have been settled by the controller, the licensee may, at any time after he has worked the invention on commercial scale for the period of not less than 12 months. So within 1 year, he make an application to the controller for the revision of terms and condition on the ground that the terms and conditions settled have proved to be more onerous than originally expected. So expected terms and conditions are revised if we have the another terms and conditions which are more onerous than the original expected terms and conditions, and that in consequence thereof the licensee is unable to work the invention except at loss. If the loss is occurring there, then licensee should apply for the revision of terms and conditions. Okay. So can you tell me any example? You can frame any example related to this section 88.4.
So consider the same case which you have showcased. So after the CIPLA gets the license and they start manufacturing and selling the respective medicine to the government of Lebong. But after some time, what they have observed is during the compulsory license agreement, they have been given certain terms and conditions by Lisa. Okay. But based on those terms and conditions, the CIPLA is going into loss. Okay.
Yes.
But they didn't realize that before getting the license, but after getting the license and while shipping the product to Lebong, they observed this loss. Okay. So, but they cannot apply immediately, but they have to wait till 12 months because it is mentioning not less than 12 months, right? So after 12 months of time, they can again approach the controller and showcase the loss that they are facing in this entire year, and to amend the terms and conditions in such a way that we may not face loss in future.
So is the royalties increased or enhanced there or not?
So the royalty may decrease to Lisa, right? Because otherwise, if they don't decrease anything under loyalty, then definitely they still will face the loss. The CIPLA will still face the loss.
Okay.
So it can be anything. It can be anything. The loss can be in any manner, not only in terms of monetary benefits. Right?
Okay. General purposes for granting compulsory licenses. The power of controller upon an application made under Section 84 shall be exercised with a view to securing the following general purposes, and it is to say that a patented invention are worked on a commercial scale in territory of India without undue delay and to the fullest extent that is reasonably practicable. That the interest of any person for the time being worked or developing an invention in territory. That the interest of any person for the that the interest of any person for the time being working on or developing an invention in the territory of India under the protection of a patent are not unfairly prejudiced. So as we already studied that the purpose for granting compulsory licensing. Okay. Second, that is section 90, terms and condition for compulsory licenses. This is also we already studied, right? In settling the terms and condition of licenses under section 84, the controller shall endeavor to secure that the royalty and other remuneration, if any, reserved to the patentee or other person beneficially entitled to the patent is reasonable, having regard to the nature of the invention, the expenditure incurred by the patentee in making the invention or in developing it and obtaining a patent and keeping it in force, and other relevant factors. That the patented invention is worked to the fullest extent by the person to whom the license is granted and with reasonably profit to him. That the patented article are made available to the public at reasonably affordable prices. That the license granted is a non-exclusive license. That the right of a licensee is non-assignable. That the license is for the balanced term of patent unless a shorter term is consistent with public interest. So the shorter term, okay, unless a shorter term is consistent with the public interest. That the license is granted with predominant purpose of supply in Indian market, and that the licensee may also export the patented product if needed in accordance with the provisions of subclause 3 of clause A of subsection 7 of section 84. So tell me this section 84(7)(a)(3), we already studied this one twice, right? Hello. Can anyone read the section 84 of subsection 7 clause A of subclause 3?
Yeah, a market for export. A market for export of patented article manufactured in India is not being supplied or developed. This is
okay. So that the license is granted with predominant purpose of supply in Indian market, and that licensee may also export the patented product if needed in accordance with the provisions of section 84 subsection 7 clause A of subclause 3. Okay. That in the case of semiconductor technology, the license granted is to work the invention for public non-commercial use. As already told you that the technology is developing very in fast speed. So fastest speed, that's why it is used for non-commercial use. That in case of license is granted to remedy a practice entertained after judicial or administrative processes to be anti-competitive, the licensee shall be permitted to export the patented product if needed be.
means
So the case in which the process to be anti-competitive. Suppose that in the case the license is granted to remedy a practice determined, sorry, this is determined, I think. Practice determined after judicial or administrative process to be anti-competitive. The license shall be permitted to export the patented product if need to be. So in the case of anti-competitive practices, also
it means what, ma'am? Anti-competitive practice means what?
Anti-competitive means suppose you can see the case of solar panels. Have you read that case?
No, ma'am. What it says?
1 minute. I will open that.
Okay.
Ma'am, just a small request. Can we cover the rest in the next week, because we have another class from 3:30 to 5:30, I guess.
Okay,
And
okay.
we need some time in
So
between.
just I'm only revising this because we already covered that one.
Yeah, sure then. Yeah.
Yes, yes.
So because I have some work, so if you want, you can continue. Then I will read through on my. Thanks.
Okay.
Thank you.
Ma'am, you are not. Ma'am, you are not audible. Ma'am, you are not audible. Please turn on your mic.
Yes, hello.
Yes, you are audible now.
Okay. So we are here that in case of a license is granted to remedy a practical practice determined after judicial or administrative process to be anti-competitive, the licensee shall be permitted to export the patented product if needed. Okay. So when you see that, read that case of solar panels, the anti-competitive practice is, the tariff is tariffed by US government. Then in that case, we can also do the licensing. Okay. Next one, that is, no license granted by the controller shall authorize the licensee to import the patented article or an article or a substance made by patented process from abroad, where such importation would, but of such authorization, constitute an infringement of the rights of a patentee. So, so there is nothing like the import license is given to that applicant. Okay, for any patented article, and which is patented outside India. Okay, so no license granted by the controller shall authorize the licensee to import the patented article or an article or a substance made by a patented process from abroad, where such importation would, but for such authorization, constitute an infringement of the rights of the patentee. So for the import or export, there is different type of license which is granted. That is export import license is there, which is granted, but controller cannot grant this type of license to import the patented article. Okay. Next one, that is, notwithstanding anything contained in subsection 2, the central government may, if in its opinion it is necessary so to do, in the public interest, direct the controller at any time to authorize any licensee in respect of a patent to import the patented article or an article or a substance made by the patented process from abroad, such subject to such conditions as it consider necessary to impose, relating among other matters to the royalty and other remuneration, if any, payable to the patentee, the quantum of import, the sale prices of the imported article, and the period of importation. And thereupon the controller shall give effects to the directions. So what is not granted by the controller, which is given here, that is in this clause, in this one. Okay. Notwithstanding anything contained in subsection 2, the central government may, if in its opinion it is necessary so to do in the public interest. So in the public interest, he will direct the controller at any time to authorize any license in respect of the patent to import the patented article or an article or a substance made by the patented process from the abroad. So the same case we can refer here, that is Labon case. President post review. Have you understood these two? That is section 9, clause 2 and 3. So in that clause 3 is important. Hello. Hello.
Ma'am, we can wrap up the session like they will read these sections, and if they have any doubt, they will ask us, and then we will discuss with you regarding all the doubts.
Okay.
Because they have another session like of drafting after 1.5 hours, so that's why I think they left. That's why.
Actually, this is already covered in the previous.
Yes, ma'am, you already covered. Yes, I saw
yes.
already. You already covered. So they will read, and if they have any doubt, they will ask us.
Okay. Yeah.
Then we will discuss with you.
Yes. Okay. Yeah.
So guys, if you have any doubt, you can ask us. Then we will connect with you with ma'am. So, okay, ma'am, you can continue. So, ma'am, can we end this session?
Yes.
As of
We
now.
can. Yeah.
Yeah. Thank you so much, ma'am, for your support. Thank you.